Hello and welcome to the latest legal update from the Solicitors Group TSG Legal TV channel. My name is Paul Butt and today I'll be discussing searches and inquiries before contract. Perhaps the first thing we ought to be reminded of, I'm sure you don't actually need reminding, is that conveyancing is a high risk area. Biggest single source of claims with regard to negligence for the legal profession. Indeed, over 50% by value of negligence claims are in relation to residential conveyancing. And one of the areas in which claims are made, one of the top 10 areas of claim, is with regard to searches and inquiries, not making sufficient searches and inquiries. So it is an important area. Obviously, in making searches and inquiries, we must bear in mind that we're doing this on behalf of the client. There's no point our finding out all this information about the property, whether through searches or inquiries, if we don't let the client know about it. The idea is to allow the client to find out as much as possible about the property, anything which may or may not influence them with proceeding with that transaction. Not matters that might influence us, matters that might influence the client. So it's essential we make a full and comprehensive report of everything we discover to the client to enable them to make an informed decision whether to proceed. And it's essential we do that at the earliest possible moment. And I say that because many people, immediately before exchange, when they're ready to exchange, do a comprehensive pre-contract report to the client. I do wonder whether that is sensible. As I say, we're ready to exchange. If there are any issues arising, any problems that the client wants advice on, it's all going to have to be done in a rush because we want to exchange straight away. Much better, I think, that we report on each individual search, each individual inquiry, as and when it comes in. I know there's arguments against that, arguments in favour of giving the one bite of the cherry approach, giving the client all the information at one go. But if you have a report that's going in that's 10, 15, 20 pages, how much of that is the client actually going to read and understand? If you have 4 or 5 separate ones, each of only a page and a bit, perhaps they're more likely to read, assimilate, understand that. Anyway, it's a question of choice. As well as thinking about our buyer client, of course, we need to think about the instructions we receive from our friends, the lenders. Very important these days with limitations on lenders' panels, keeping the lenders happy, particularly as lenders are now increasingly monitoring the files, checking up on what we do, if you like. What the Lender's Handbook says is that we must ensure that all usual and necessary searches and inquiries have been carried out. What are usual and necessary searches? The Law City Conveyancing Handbook deals with that. It says quite clearly what that means is the local search and the additional inquiries, a drainage and water search, and preliminary inquiries, property information form. Those are the usual and necessary. But I'm sure we all know of firms that don't do a drainage and water search. They don't do the search in order to give a lower quote to clients in order to try and get the business. But of course, they're not complying with lenders' requirements, not doing that drainage and water search. So I think there obviously are issues there that they need to be aware of. Talking of drainage and water searches, as we were, standard thing that most of us do take care with those now. Remember that since the 1st of October 2011, most drains, sewers that were previously private, previously maintained by the property owner, are now going to be in public maintenance. Once the actual drain, the sewer, passes out of the boundary of your property, not necessarily direct to the main sewer, but over next door's garden, it then becomes publicly maintained. So we need to be aware of this. We need to beware of this. The big advantage, of course, of these being publicly maintained is that if there is a blockage in that sewer, before last October you'd have to pay a lot of money for a private contractor to come out to clear it. Now it's the Drainage and Water Company's obligation to do so. The downside, of course, that will increase the cost of your water and sewage bills to cover the cost of doing this for other people. But equally, there's a downside with regard to build-over agreements. I'm sure we all know that if you want to build over a public sewer, you need permission. Now we have lots and lots of more sewers that are public, in that sense of the word, lots and lots of more occasions, therefore, where we'll need to consider a build-over agreement. And it isn't just an agreement to build over the structure, over the drain. Any structure that's within 3 meters of either side of that sewer needs permission. That's to enable the water authority to have room to get equipment in if they need to do so to repair that sewer. So we need to be considering where we have these previously private, now public sewers crossing people's back gardens, front gardens, down the side of the property. This is seriously going to limit their ability to build conservatories extensions. This is something as a buyer will need to be looking out for in the future. If it's within 3 meters of one of these new public sewers, a build-over agreement will be necessary. Something that's going to cause a problem on sales into the future. We need to be checking this. We need to be warning clients buying property now that there's going to be sewers in their garden, in most cases that are public, that is going to inhibit their ability to build extensions. If they don't get a build-over agreement, the danger is that the whole structure could be in danger of being demolished, which is not something you want to take the risk of doing if you're buying that property. Anything within 3 meters is at risk. So, local search, additional inquiries, drainage and water, pre-contract inquiries of the seller. In addition to that, the lenders say that we must ensure that any other searches which may be appropriate to the particular property, taking into account its locality and other features, are carried out. And that's the difficult one. Other searches which may be appropriate to the particular property, taking into account its locality and other features. Now, we may well know that in our own area, the area in which we practice, that it's usual to make a mining search, maybe coal mining, salt, china clay mining, or whatever it might be. We practice in this area, we know about that. The difficulty is clients tend to want to buy properties outside the area with which we're familiar. But we're supposed to know what searches are appropriate in whatever area of the country the client decides to buy a property. And that is the difficulty. If you look at the list of different searches that are available, some search providers have up to 70 different searches, which we're supposed to know about. We're supposed to know when they're appropriate to the particular property. If we don't carry out that search and loss is suffered, then of course we're going to be liable to the client. So we're looking at Tyneside Metro searches, Docklands Light Railway, limestone mining searches in the West Midlands, etc., etc. It must be sensible to try and build up some kind of in-house database. You might know what searches are appropriate when buying property in Kent, but maybe somebody else in the firm does. And I mentioned Kent because certain parts of Kent it will be necessary to do a mining search, coal mining search, which perhaps otherwise we wouldn't think about. One or two other searches I think we might mention. Dare I mention chancel repair liability? People have very strong views on that. Some people do it in all cases, do a screening search or take out insurance. Others think it's just a waste of time, waste of money. It's a waste of your money if the property you're buying does turn out to be affected by chancel repair liability. We know about these searches, we know about the risks involved. If you want to take that risk on yourself, that's up to you. Very, very, very small risk, of course, maybe 1 in a million. But why take any risk at all? Your buyer client could make an informed decision. You could explain the risks and the buyer may decide not to bother. What about your lender client? What the lenders say, in the thing specific in the handbook, one of the frequently asked questions which is dealt with on the CML website, says it's up to the conveyancer to decide what searches are appropriate. So lenders are reserving the right to blame you if the liability to chancel repair would affect the value of the property. So you make your own decision. But what about all the other searches that are available? What about flooding? Isn't that something that must these days be usual and necessary? I'd have thought so. Virtually every week, even in the middle of drought, we have worries, we have reports of floods. I think most clients would expect to be told about that. They expect that we should do this search. There are lots of searches that the search providers have come up with: plan search, ground stability searches. We know these things are available. These are genuine things, genuine choices to be given to a buyer client. But they can only make an informed choice if we explain that these things are available, if we explain what the risks are, the reasons for having them, the risks of not having them. We need to make sure we're doing this. Otherwise, again, if somebody suffers damage because a bail hostel is to be opened next door, or something that might affect the value of the property, they suffer loss because of that, the property price is reduced, which wouldn't have been the case had we done plan search, then we could find ourselves liable for negligence in that situation. Obviously, we've got to make lots of pre-contract searches and inquiries, the standard protocol forms. We should be very careful about raising additional searches. Protocol does say that we should really only raise ones that are appropriate to the particular property, not long general fishing lists, which everybody annoys. We need to be very careful about raising extra ones. So do be specific to the particular property. One particular thing I want to mention is with regard to neighbour disputes. Recent case, Court of Appeal last year, called Zarb and Parry, gives rise to this. Sorry.
You've got 3 minutes left on 10. So I can stick to that.
Oh, sorry, yes, I could see the light flashing. It was flashing on me. I wonder what it was, yeah. Oh, I see. Yeah, well. Okay. Case in the Court of Appeal last year called Zarb and Parry. And there'd previously been boundary issues between the seller and the seller's neighbours. There was a problem. The neighbours were alleging a fence was in the wrong place. And there were discussions about this, and nothing happened. The seller genuinely thought that the problem had gone away, but reported in the property information form, clearly stated, yes, there had been this problem, but it had been sorted out. Buyers bought the property in reliance on that. Unfortunately, the boundary problem had not gone away. The neighbours next door resurrected it, and they ended up having to go to the Court of Appeal to sort matters out. Eventually, the buyers of the property in question won, but having had to go to the Court of Appeal. The point I want to make is that in the proceedings, Lady Justice Arden referred to the fact that there'd previously been this dispute and placed an additional burden on purchasers' solicitors, saying that purchasers are not necessarily protected merely because the seller gives an assurance that the dispute has gone away. Boundary disputes have a habit of reappearing until finally resolved. The neighbour may, for whatever reason, resuscitate the dispute. It may be that the purchaser will have to consider whether to ask the neighbour to confirm that the boundaries are now settled. Ask the neighbour to confirm that the dispute has been resolved. This is something we ought to be thinking about. If we don't do that, then, as there is guidance, advice from the Court of Appeal that we ought to be doing it, then we are the ones as solicitors that are going to be negligent, are going to be liable. So do be careful with the replies that we get to these preliminary inquiries. Anything that says there's been a problem and it's gone away, we do need to ensure that that problem really has gone away. It's our necks on the line. On behalf of myself and the Solicitors Group, I would like to thank you for listening to this legal update. Do keep an eye out for further updates from TSGLegalTV, and we all look forward to seeing you again soon. Third time, fourth time lucky.